cover the competition law aspect around the distribution of digital media with a focus, at least in large part, on online platform. There's a lot happening around the application, the enforcement of antitrust and online platforms. Online platforms, because they gathered users, consumers, suppliers, raises all sort of very challenging issues for the antitrust enforcement and for the authorities, and it's keeping us busy, I would say, competition law lawyers, and I'm sure it's going to be like that for many years to come. You will see, I have prepared for you a presentation which is quite detailed, which gives you an overview of the different areas which Florence mentioned, pure antitrust, abuse of dominant position, and merger control. I will, in the interest of time, and also to ensure that you have the possibility to raise questions or make comments, I'll keep that short and really focus on the highlights in the next 30 minutes. So don't expect me to follow religiously my presentation, but I will pick up a few points, and then we'll see where we get to. We'll stop after 30 minutes, and we can then have a discussion, and you can feel free to raise any questions. So, competition law applies in the online world in the same way as in the offline world, and there is no digital Wild West, and you see that Commissioner Jourova said that. I think she was saying that, in relation to illegal content on internet platforms, but actually you can say the same about the application of antitrust, which applies in the same way in the online world and to online platforms as any, offline environments. And a lot of focus on this. As I've said, you'll see what I will try to cover over the next 30 minutes. Very quickly, a definition of online platforms. I mean, in competition law, well, there hasn't been, and there's not a definition as such of online platform. The European Commission, when it published its communication on online platforms and the need to regulate or not online platform in 2015, tried to look as to whether there was a consensus on a definition of what is an online platform, and there's not. So the Commission focused on then 4 characteristics which you find in these platforms and which are very relevant from an antitrust perspective. And the first one is the capacity for any platform to facilitate and extract value from different interaction between users. That's one of the main characteristics of platforms. A second very important one, we'll come back to that, the ability to collect, use and process a large amount of personal and non-personal data in order to optimize the service and the experience of the user. So that's the data aggregation capacity. When you think about the big platform, Google, Facebook, they have a lot of data. Does that raise an issue from an antitrust perspective or not? That's an issue we'll come back on. A third characteristic, you have heard about the concept of network effects, and basically the utility that the user can receive from a service directly increases as the number of other users increases. Whether these are users, the same types of users, you think about a platform like Facebook, the more users you have, the more valuable it becomes. Users can be on both sides, and if you take, Facebook, well, the larger number of users, the more valuable the platform becomes for advertisers. So that's the so-called, indirect effect, where the value of a platform increases for a group of users when you have more users on the other side. It doesn't go the other way necessarily. It's not like because you have more advertisers features that, actually users would like a platform. On the contrary, they may find it disruptive. So these are, so-called direct and indirect network effects, very important characteristic of platform, also highly relevant for network effects, or for competition analysis. And then the fourth characteristic of a platform, according to the European Commission, is the use of information and communication technology in order to achieve, the effects I've just mentioned. So these are, this is the way, the European Commission has defined what a platform is. And then you have here, they don't show, but you have here, different types of platforms that you're familiar with. And, a number of them have already been the subject of competition law investigation, Amazon, Google, Facebook, and we'll come back to that, eBay as well. So, all types of platforms, and, again, we're going to now jump into relevant antitrust issues around platform. Yeah, look, that's, you might have heard of this lady. She's Danish, is Commissioner Vester. She's in charge of competition at the European Commission. And she said, we have to be in control of what goes wrong in order to make the most of online platforms, big tech, big data, and artificial intelligence. So there's really a clear focus, not only of the European Commission, but also of national competition authorities around platform. It's very sexy, for authorities to investigate and come up with cases around platform, and there's also some form of competition, which is an issue, because these platforms are cross-border, and once you have different regulators as well as competition authorities looking at the same issues, there's a potential for conflict. So that's, but on the other hand, they're not necessarily waiting for each other to act. There's some form of coordination, but that's a big issue that we are facing, is the possible multiple and conflicting outcome from different intervention by competition authorities. Now, we focus in competition law on two types of concern. You have the so-called vertical and horizontal concern. And they're both relevant around platform. Platforms generally would gather and be an intermediary between different types of users, suppliers, and users being consumers, and the platform is in between. So you have, there a vertical relationship between different players on the market, the platforms and the different types of users, suppliers, and so on using the platform. So there is there the possibility of vertical restraints, and then there's also platforms can play a role in terms of facilitating coordination between, companies, businesses active at the same level. That's the so-called horizontal concern risk that also can be generated by the use of platform. So now, focusing, I'll pick up, just a few issues here. On the vertical restraints, one of the focus of competition authorities so far around platform has been in relation to pricing restriction and so-called parity clauses that you find being used by certain platforms. And I give you two examples. There's been the e-book investigation and concerning Apple. Basically, Apple had agreed with the publishers a so-called parity clause, which requires basically the publisher not to give any better pricing to competing platform to Apple. So whatever pricing they were giving to Apple, well, they could not undercut and give a lower pricing if they were distributing, for instance, via Amazon. And Amazon actually is the company that complained against this e-book arrangement around Apple. They were considered as being restrictive of competition, disparity clauses, because basically they prevent pricing competition. They prevent the entry of a new platform that may decide, I'm going to price at a lower price. Well, if you have such a parity clause agreed between publishers and Apple, that's not possible. So the European Commission objected to that, and Apple had to put an end to it. There was a similar investigation around the booking, the hotel booking platforms. You probably have heard about that, Booking.com, Expedia. have been investigated in a number of countries. I was telling you about the risk of conflicting outcome. You know, you had investigation in the UK, in Italy, in France, in Germany, around the same issue. You know, Booking.com basically is asking was asking all hotel owners to not give lower price to any competing platforms, or even advertise lower prices than the prices which were advertised on Booking.com. That was considered as being anti-competitive for the same reason I've explained in relation to the e-book investigation. But, you know, there were different outcomes in the different investigations. Some of the authorities considered that it was possible for Booking.com to restrict the ability of the hotel owners to offer lower price on their own website, but it was illegal to prevent competing platform to potentially advertise and offer lower price. So that's the so-called narrow parity clause, whereas that was the case in France, Italy, and the UK. And Germany said, well, any parity clause of the type I've just mentioned, whether it's broad or narrow, is illegal. Then eventually, not only had you conflicting results between the different competition authorities, but then certain countries, Italy, France, decided to adopt a legislation that was prohibiting this sort of clause. So you have multiple interventions with different views and different outcomes, which is absolutely not satisfactory, obviously, in terms of legal certainty for the companies involved. So another focus has been around geographic restriction and, you know, the geo-blocking. You are familiar with the geo-blocking. Is basically a restriction on access on a website in a specific country, say, or Belgium, for customers that would be located, you know, in other countries, where you would basically, if you try to access, you know, from France a Belgian website, access will be refused, or you will be redirected to a French website. And these sort of practice have been investigated by the Commission as part of the e-commerce investigation. And basically the Commission say, with this type of clause, they prevent, you know, the freedom for customers, for users, to benefit from the single market and to buy services or products outside of their own countries. So there was an investigation. So the geo-blocking was also the subject of an investigation by the Commission around Sky and the Hollywood studios, where basically, you know, you had the Hollywood studio had agreed to give an absolute territorial protection to Sky in the UK, and that means that users located outside of the UK could not access films of the Hollywood studios, you know, on Sky in the UK. And, you know, this investigation is still ongoing. It's a good example of, you know, an investigation concerning geo-blocking. It has been now pending for a few years. One of the Hollywood studio, Paramount, has settled the cases, but, you know, we're still waiting for the outcome. I suppose it will be adopted in the next few months. Now, that was for the vertical restraints. In terms of the horizontal restraints, platform can also play a role in favoring possibly collusion among competitors. And you know, you have the so-called hub and spoke concept, where you have the hub, you have someone in between. That can be, for instance, a platform which is used by, you know, the spokes, the competitors that would use the platforms in order to you know, benefit from some synergies. But as a result of that, you know, the platform can play a role in order to encourage or favor you know, price coordination. And I give you, you know, an example of that is the Etura's case, which concern, you know, the administrator of a Lithuanian online travel booking system that was used by travel agents, and then basically at some point of time, you know, the platform, the hub, sent, you know, a message to all the travel agents, which were competitors by definition. Of course, travel agents compete among themselves. It was a message sent by the platform to the different travel agents saying, look, as of now, your potential discount of your commissions is capped 3%. If competitors agreed among themselves to cap the level of their discount at a specific percentage level, 3%, that's illegal. They hasn't spoken to each other, the agents. It was just the message was passed on by the platform. So that's an example of a hub and spoke, where actually the platform can be an instrument to collude. And there, there was a judgment of the Court of Justice that says, look, if you are a travel agent on this platform, and you have received that information, the message, cap your commission at 3%, and you haven't done anything, you are deemed to have used that information to collude. And actually, the European Court said that you should have distanced yourself. You should have sent a message to the platform saying, I don't want to receive that sort of message. I'm not bound by it. And those which did not do that could have been held as having committed an infringement of competition law by colluding among competitors. So you can see here really platforms, potentially, yes, reaching synergies, but also raising a risk of potential collusion. By the way, there's a case in the US around the Uber platform, exactly around that. Uber is independent from the taxi drivers, which are also competitors among themselves. And the question is, Uber has a price algorithm, which basically means that, the taxi drivers are not competing for the price of the fare, and basically then the question which is in front of a court in the US, is this a big cartel? And Uber favors and encourages a coordination through the use of a price algorithm among the taxi drivers. I mean, that's a very important case for Uber, as you can imagine, because this is their business model which is at stake here. A lot of interest around, the use of price algorithm. I've just mentioned one to you. As companies and platforms develop price algorithm, they have really to be mindful of the fact that these price algorithms can lead and facilitate collusion. That there's really a big focus on competition authorities. This is not easy because normally, if you want to prove a cartel, you have to show meetings or contacts. And obviously now, with this price algorithm being used by competitors, well, people don't need to speak to each other. Price algorithm potentially of two competitors could speak to each other. Is this a cartel or not? To the extent that you don't have human contacts. These are very new and challenging issues for competition authorities that they have to deal with. I don't have the answers, they don't have the answers, but tomorrow they'll have to have one because they are concerned around that price algorithm reduce price competition for us all consumers. So competition authorities are going to be more and more focused on this. You have heard about abuse of dominant position, again, valid in the offline world. It raises new challenges in the online world, because online means technology, means innovation. So, when is a company dominant? You've heard about MySpace being replaced by Facebook. There's a cycle of innovation which is very high around technology, around platforms. But, nevertheless, it is clear that competition authorities consider that certain platforms, namely, Facebook, Google, Amazon, are, arguably dominant. And what they have used there in terms to determine whether these companies are dominant, in the offline world, generally, if you have a market share on whatever your market is of above 40%, you're deemed to be dominant. Now, you would say, in the online world, again, things are changing so rapidly, maybe market shares are less reliable in terms of showing a market power. And that's why there is now an increased focus for competition authorities in order to establish market power or dominance on the data and the fact that certain companies have accumulated through their activities an incredible amount of data, and that put them arguably, allegedly, in a dominant position. And so that's a slightly different way to apprehend and define the concept of dominance in the online world, more focus on data, which you know is becoming the most essential asset in this new environment. Different types of potential abusers. You have the so-called exploitative conduct, which basically do what they say, exploit generally users. And an example of that, I was just mentioning Facebook at the moment. Facebook is being investigated at the moment in Germany. The competition authorities has considered that Facebook is dominant on the market of private social network, where they would have a market share of 90%. And there, what is the abuse? What is the problem there? Well, what the German authorities are saying is that because of this dominant position of Facebook in private social network, they're able to extract users' data in a way which is excessive. And Facebook had already been sanctioned for violation of data protection law in Germany for extracting too much data or with or without sufficient and informed consent from users. But, so there was a condemnation of data on the data protection regulation, but the competition authorities are, in parallel, conducting this investigation, which, again, may or may not lead. The jury is out. The decision will probably be adopted by the end of this year. May consider that by extracting so much information from users, by not informing them, in violation of data protection law, that behavior also constitute an abuse of dominant position with potentially significant fines. So that's a very interesting case, this case, because it's about the relationship between the application of antitrust and the application of other type of regulations. You could say that for data protection law. You could say that for different types of consumer protection law. Is it okay that you have the possibility to apply competition law to second guess maybe the specific provision of pieces of regulation? That's the debate which is at stake as part of the WhatsApp investigation. And then you have moving from exploitative abuses to exclusionary conducts, which aim, at excluding, foreclosing competitors. There you have, a number of cases there, but I'll focus, because I speak about data. There, the question which is relevant is, again, coming back to the fact that certain companies have accumulated so much data, and this data is so valuable in order to provide, focused services or supply, products in a very focused way to their customers, that, competitors would say, well, I can't compete with this company unless I have access to this data. And the question that is then relevant is the data pool that certain companies own, is it a so-called essential facility? Essential facility is a concept, an old concept of competition law, which developed around, network, big telecom network and so on, which could not be replicated by competitors. But can you say the same about a data pool? Is the data pool so unique that nobody else can do it? And that means that if I want to compete with you, Facebook, Google, because you have so much data, I need to have access to your data. Otherwise, I can't compete. That's the argument that certain companies are making. If you think about the connected cars, and car manufacturers are developing now inbuilt devices that will collate, or are collating, an enormous amount of data about your driving behavior. You can imagine that these data are very interesting for a number of competing service providers. Think, all the car manufacturers have their in-house insurance companies. Well, if you're not related to a car manufacturer, you're an insurance company, you may want to have access to this data. Is this data unique? Does that put car manufacturers and their insurance company sisters in a unique position so that tomorrow insurance company will not be able to compete with them unless they have access to this data? Again, this is an open question. But I can tell you, there have been one case, at least that I'm aware of, in a completely different sector where competition authorities have considered that data pool was essential and have ordered access to competitors. It concerned Engie in France. Engie, you know, the mother company of Electrabel, had accumulated a lot of data because it was the universal service provider of certain gas and electricity customers in France. And obviously, based on that data, now that the market was open to competition, was liberalized, they were able to use that data to provide much more focused services than new entrants. And the new entrants went to the competition authority and said, look, we can't compete unless we have access to this data. And, you know, and the competition authorities in that case granted access to the data. So it may be, you know, a case that we're going to see more and more going forward. I'll move on. You know, you have heard about probably the Google case. Google is subject to a number of investigations, being a company, you know, again, that owns a lot of data. They have been fined in June of last year for, you know, the largest fine, I believe, imposed so far by the European Commission, 2.42 billion euros for abusing their dominance on the general search engine market and leveraging this dominant position into the market of comparison shopping services. And Google is basically alleged to have given prominent placements to its own comparison shopping services at or near the top of its general search result, while, of course, demoting rival comparison shopping services. And, you know, so there's been the sanction. Google has been required to change its system. And now, basically, they have opened the shopping box on the search page of Google to an auction system. Whether that will do the trick or not, you know, is still out because the Commission is looking into this. There's an appeal pending. They've also, you know, I was telling you about the fine. There are also an enormous amount of private claim for damages, you know, competing shopping comparison website and services providers, which claim that for many years they have been foreclosed from the market, asking, you know, compensation to Google. On merger control, on merger control threshold, you know, the problem that competition authorities are facing is that a lot of the startup companies, platforms, don't have any turnover, or very little. If you think about WhatsApp, when it was acquired by Facebook for, I think, 18 to 19 billion dollars, it didn't have or had a very negligible turnover. And in terms of merger control threshold, only, you know, mergers between companies that achieve certain level of turnover have to be fined. It's the problem because the authorities say, well, if these companies like WhatsApp, you know, don't have any turnover, then we can't intervene. Now, WhatsApp was reviewed by the European Commission because it met certain national threshold, and then the authorities referred the matter to the EU, but that was almost by sheer luck that it was reviewed by the European Commission. So there is this proposal to change the merger control system, and basically now to foresee that even though the platform acquired by the acquirer here, WhatsApp, wouldn't have any turnover, if the transaction value is above a certain threshold, you know, of 400 million euros in Germany, which has just changed its regime, then the transaction will be notifiable to the European, to the competition authority. So Germany has changed its system to catch this sort of acquisition of platform without turnover. So has Austria. The Europe at EU level, you know, there's been a debate. It's likely not going to happen. On substance, you know, as companies acquire others, as you know, of course the pooling of data. Because, you know, data is so valuable, is going to be and has become an increased focus as authorities review the impact of mergers. That was certainly the case in Facebook, WhatsApp, Microsoft, LinkedIn. What is going to be the impact of merging the two data pools owned by the two companies merging? Are you going to create a big pool, again, unique, to which, that nobody else would be able to replicate. And then you have the privacy concern. Would the merger lead to a reduction of the privacy-enhancing feature of one platform? That was an issue at stake in WhatsApp. And then the question, an interesting question, coming back to what I was talking early on, the fact that the merger can be negative on the privacy-enhancing feature of a certain platform. WhatsApp now, within the Facebook environment, may reduce its privacy protection for users. Is it something that competition authorities should look at? Or is it something for the data protection authorities only? The Commission said in WhatsApp, yeah, that's not for us. That's for data protection authorities. Now, if you read Microsoft LinkedIn, you can see that competition authorities are changing their approach. Because in relation to platform where the services are for free, it is clear that whether a platform provides a sufficient level of privacy protection is an element of choice for users. And so it's a non-pricing parameter of competition that, in my view, competition authorities have to take into account when they assess the potential negative impact of mergers. And I think we're going to see that happening more and more. What is going to be the impact on privacy of merging two companies? I think that, I'll probably, stop here, because you will see that I focus on Europe. There's a lot of enforcement around platforms in other areas of the world. Asia in particular, less in the US. I was talking to you about the Google case. The US authorities investigated the same Google issues about, demoting or giving prominence to its own downstream services, comparison shopping services, and the US found that there was no problem. Again, different outcome across the Atlantic and among competition authorities. There is a proposal on the regulation of online platforms. It is clear that platforms play more and more of an important role, not only for private users, but also for professional users. And there is a high degree of dependency of certain businesses on access to certain platforms. And in order to reduce this imbalance, the European Commission is proposing a regulation that would actually require the platform to be much more transparent as to the condition at which they give access or provide their services. And in particular, they will be, coming back to the Google case, they will be required to disclose the parameters that they use to rank services. Whether by paying a fee, you can benefit from a higher ranking, in whatever search engine used by the platform. That is something that will have to be published in the future. So it's not yet law, it still needs to go to the legislative process, but that's an interesting case as well. I have covered the Facebook case in Germany. There is a B2B platform guidance published by the German competition authorities, which is also a very interesting document if you are interested in these issues. And last but not least, talking about merger control in the US, you probably have heard, because you are interested in the media sector, that the AT&T Time Warner merger is being investigated by the US, and there are very significant issues which have been raised surprisingly, because there you have the integration between a content provider, essentially Time Warner, and a telecommunication network provider, AT&T. And then the concern is that, as a result of, it's a vertical concern, as a result of the merger, the Time Warner content would not be made available to competitors to AT&T. So there's the sort of foreclosure concern that may result from the merger. That's something that, in the US, being not very much interventionist, vertical mergers have never been the subject of serious issues in the US, but surprisingly, the competition authorities have taken this merger to court to stop it. In the US, they have to go to court. The European Commission can stop itself mergers. It's not possible in the US. Whether this has been influenced by the fact that President Trump doesn't like CNN, as you all know, I don't know. Don't want to think it is the case, but who knows? I don't know. But the jury is out, and there will be again, I suppose, a decision by the U.S. courts later this year. It's going to be an interesting case to follow as well.